Introduction: Why communication of material information matters. One of the most important responsibilities of a real estate professional is the accurate communication of material information to clients and other parties in a transaction. Real estate agents serve as a conduit of information between buyers, sellers, lenders, inspectors, title companies, and other professionals involved in a transaction. Because real estate decisions often involve large financial commitments, the law requires licensees to communicate information honestly, accurately, and in a timely manner. Failure to properly communicate material information can result in consumer harm, civil liability, and disciplinary action by the Arizona Department of Real Estate. Arizona law expects licensees to exercise reasonable care when communicating information about property conditions, contractual obligations, financing terms, and other facts that could affect a client's decision. When communication breaks down, misunderstandings can occur, and those misunderstandings frequently lead to disputes or legal claims. For this reason, Arizona statutes, administrative rules, and legal case precedent emphasize the duty of licensees to communicate material information clearly and accurately. A. ADRE Rule on Communication. The Arizona Administrative Code directly addresses the responsibility of licensees to communicate information honestly and with reasonable care. Under AAC R428-1101, licensees must protect and promote the client's interests while also dealing fairly with all parties in the transaction. This rule establishes the expectation that licensees will communicate information accurately and avoid misrepresentation or concealment of material facts. The rule requires licensees to disclose any information that materially and adversely affects the consideration to be paid by a party to the transaction, including information about the property itself or the ability of the parties to perform under the contract. This duty applies regardless of whether the information is learned directly from the seller, discovered during the transaction process, or obtained from third-party reports. In practice, this means that if a real estate agent becomes aware of a defect in the property that could influence a buyer's decision, the agent must ensure that the information is properly communicated. For example, if a listing agent in Chandler learns that the roof has active leaks that were previously repaired but not fully resolved, that information must be disclosed. Even if the seller prefers not to highlight the issue, the licensee cannot conceal known material defects. The rule is designed to protect the public and prevent situations where buyers enter into transactions without full knowledge of relevant facts. B. Substantive Policy Statement Guidance. In addition to administrative rules, the Arizona Department of Real Estate provides guidance through substantive policy statements, which explain how the department interprets professional conduct standards. These statements clarify that licensees must communicate information accurately and must not provide advice outside the scope of their professional expertise. For example, real estate agents are not licensed home inspectors, engineers, or attorneys. While agents may relay information obtained during inspections or review reports with clients, they should avoid interpreting technical findings in ways that could be considered professional advice. Instead, agents should encourage clients to consult qualified professionals when specialized expertise is required. Policy statements also emphasize that licensees must avoid creating misleading impressions through incomplete communication. Providing partial information that leads a client to believe something inaccurate may be considered misrepresentation, even if the agent did not intentionally lie. For example, if a buyer asks whether a property has had water damage and the agent knows the seller previously filed an insurance claim related to flooding, the agent cannot simply respond that the home currently appears dry. The full context of the prior damage should be disclosed so the buyer can make an informed decision. C. Restatement, second, of torts. Paragraph 552 and negligent misrepresentation. The legal concept of negligent misrepresentation plays an important role in real estate transactions. Courts often reference restatement, second, of torts, paragraph 552, which addresses liability for providing false information in business transactions. Under this doctrine, a professional who provides information during the course of business may be liable if the information is supplied negligently and another party reasonably relies on it to their detriment. In real estate transactions, negligent misrepresentation can occur when an agent communicates inaccurate information about a property, financing terms, zoning status, or other material facts. Even if the agent did not intend to deceive anyone, liability can arise if the information was communicated carelessly and caused financial harm to a party relying on that information. For example, imagine a buyer's agent in Mesa tells a client that a property is eligible for short-term rental use without verifying local regulations. The buyer purchases the property intending to operate a vacation rental, but later discovers that the city zoning restrictions prohibit short-term rentals in that neighborhood. If the buyer relied on the agent's statement when making the purchase decision, the agent could potentially face a negligent misrepresentation claim. This legal doctrine reinforces the importance of verifying information before communicating it to clients. D. Reasonable reliance and risk management. A key element in negligent misrepresentation cases is the concept of reasonable reliance. Courts evaluate whether the party receiving the information reasonably relied on the statement when making a decision. In real estate transactions, buyers and sellers frequently rely on the expertise of their agents when evaluating properties, negotiating contracts, and understanding transaction risks. Because agents occupy a position of trust, their statements can carry significant weight. For this reason, licensees must practice careful risk management when communicating information. One effective risk management strategy is documenting communications in writing. Written documentation ensures that clients receive accurate information and creates a record of what was communicated during the transaction. Email summaries, transaction notes, and confirmation messages can all serve as documentation that protects both the client and the agent. Another risk management practice is verifying information before communicating it. If an agent is unsure about a zoning rule, homeowners association restriction, or utility condition, the safest approach is to recommend that the client confirm the information with the appropriate authority. By encouraging clients to verify critical information through qualified professionals, licensees reduce the risk of miscommunication and potential liability. E. Practical application in buyer and seller representation. The duty to communicate material information applies differently, depending on whether the agent represents the buyer or the seller. When representing sellers, listing agents must ensure that all known material defects are properly disclosed. This often involves reviewing the seller property disclosure statement with the seller and confirming that all questions are answered honestly and completely. If the listing agent becomes aware of information that contradicts the seller's disclosure, the agent must address the issue and ensure accurate disclosure occurs. When representing buyers agents must communicate information obtained during inspections, title reviews, neighborhood research, and financing discussions. Buyers' agents also play a critical role in ensuring buyers understand deadlines, contingencies, and potential risks associated with the transaction. For example, if an inspection report identifies structural concerns with a property in Queen Creek, the buyer's agent should ensure the buyer understands the significance of the issue and knows their options during the inspection period. While the agent should not provide engineering advice, they can encourage the buyer to consult a licensed structural engineer before proceeding with the purchase. Clear communication during these stages helps clients make informed decisions and prevents disputes after closing. Discussion questions. Why does Arizona law require real estate agents to communicate material information to clients and other parties in a transaction? Answer. Because real estate decisions involve significant financial risk, and accurate communication ensures that buyers and sellers have the information necessary to make informed decisions. How can negligent misrepresentation occur in a real estate transaction even if the agent did not intend to mislead anyone? Answer. Negligent misrepresentation can occur when an agent provides inaccurate information without verifying it, and a client reasonably relies on that information when making a financial decision. What are 2 risk management practices that agents can use to reduce the chance of miscommunication with clients? Answer. Documenting communications in writing and verifying important information with qualified professionals before sharing it with clients.